Swayam Prabha. Digital India. Educated India.
Hello friends, this is the second session on the course of law relating to women and children. In earlier session, that is the first lecture on the subject, I have discussed about the international law relating to the protection of women and children. In the present lecture, I will discuss the constitutional provisions relating to the women and children or the constitutional provision for the protection of women and children. Friends, the women are the supreme gift of God. They are the supreme gift of God as they know what is good, and therefore they know what is to create which is good and what is to devastate that is bad. But at the same time, it is also true that in India the women have been the subject of the discrimination and they could not develop or they could not avail their rights because of different social impediments. The women have been the victim of tyranny in the hands of men from the centuries. It is also the fact that the children have been the responsibility of women and therefore they have also been the subject of neglect and ignorance. It is the fact that women being the half of the population and children being the future human resource of the country are certainly the assets to the nation. After the commencement of Indian Constitution, the concerns about women and children were taken into account and the makers of our constitution, they considered several legislations, they considered the situation of women and therefore several legislations were enacted to protect the rights of women and children in India. Particularly the law relating to the women, the international law, the constitutional law and the legislative initiatives on the part of the legislature in India, these are the three important parts. As to the constitutional protection to the women and children, it is the fact that after the commencement of Indian Constitution, the makers of our constitution, they took into consideration the different position of women and therefore they included several provisions to protect the rights of women and children. In this background, the study of the law relating to women, it becomes very important and significant. In the same background, it is also important for us to know that what are the different constitutional provisions relating to the protection of women and children. There was significant contribution of women in our national movement for independence. We know this fact. There are several names who participated in the national struggle or national movement for the independence in India. Women from all the walks of life, women from all the fields, they participated into that great struggle for the movement for the independence of our country. And it was also the fact that on one hand, women in the country were showing that their potential in their social, economic and political life, but on the other hand, Indian society was not seemed to be willing to give the equal rights to the women. On one part, it has also been the part of our culture where it is said that yastu naryastu pujyante ramante tatra devata. The other hand, we also see different social impediments in the form of social traditions, in the form of religious traditions, in the form of customs, that women were not considered equal to the men. Independence of the country from British rule, followed by the making of our own constitution, created the conditions for rethinking about this traditional attitude and for providing a constitutional guarantee of equality of status and opportunity for women in India. The makers of Indian constitution, they were very well aware of the fact that within the existing socio-cultural conditions, the gender equality and gender justice may not be possible only by providing the general provisions of equality, and therefore, they advocated and recommended for some special provisions to be included in the constitution, especially for women and children, particularly in the part 3 of Indian constitution, that is the fundamental rights, and part 4 of Indian constitution, that is the directive principles of state policy. Accordingly, a number of such provisions were included in the constitution to promote and protect the interest of women and children by providing for protective discrimination. If we see these provisions of Indian constitution which relates to children, these provisions we can divide into two. The general provisions of Indian constitution protecting the fundamental rights of all the citizens. The women are also included within this generalization of protection of rights, because all the persons, everyone, every individual is given the guarantee to the fundamental rights in part 3. And number 2, what are the separate provisions or what are the special provisions which have been included within the constitution for the protection of women. As to the general provisions in part 3, we can refer to article 14. Article 14 refers to the equality before law, and it states that the state shall not deny to any person equality before law or the equal protection of the laws within the territory of India. The state shall not deny to any person equality before law or the equal protection of laws within the territory of India. It means that every person is equal and there would not be any discrimination on the basis of any ground to treat anybody with equality or for the purpose of equality before law and the equal protection of the laws. There would not be any discrimination. All the persons, whether they are men or women, whether they are adults or children, whether they are adolescents or growing people or the growing children, they are old aged person, no discrimination can be made on all these grounds, and therefore, the equal protection of laws will be given to all the persons irrespective of their age, irrespective of their sex, irrespective of their place of birth, irrespective of their caste, irrespective of their gender, irrespective of their place of birth, etc., place of residence, etc. So, article 14 gives the guarantee of equality to all, the guarantee of equality to every person, including men and women. So, this was the first step of the makers of Indian constitution under fundamental rights, where the gender discrimination was disallowed, where the discrimination on any ground was allowed for the guarantee of equality, and all were treated as equal before law. Then comes article 15. See article 15, it prohibits the discrimination on ground of religion, race, caste, sex or place of birth. Clause 1 of article 15 provides that the state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, place of birth or any of them. The particular basis, the particular grounds are given in article 15 on which the discrimination cannot be made. Article 14 provides for the general equality and it seems that Article 15 is the extension of that equality clause or the general equality or general guarantee of equality, wherein certain grounds have been mentioned, certain grounds have been pointed out, that only on these grounds the discrimination cannot be made. So, Article 15 prohibits the discrimination on the ground of religion, on the ground of race, on the ground of caste, on the ground of sex, on the ground of place of birth. See clause 2 of Article 15. No citizen shall, on grounds only of religion, race, caste, sex, place of birth, or any of them, be subject to any disability, liability, restriction, or condition. If we read clause 1 and clause 2 together, 2 points are very important to be discussed. That clause 1 of Article 15 prohibits discrimination on the ground of religion, on the ground of race, on the ground of caste, on the ground of sex, on the ground of place of birth. And Article 15 clause 2 prohibits any kinds of restrictions or any kind of conditions only on the ground of religion, only on the ground of race, only on the ground of caste, only on the ground of place of birth, only on the ground of sex. At both the places, either it is Article 15 clause 1 or it is Article 15 clause 2, at both the places we find the ground of sex on which the discrimination is not allowed, and where nobody can be subject to any conditions or restrictions, or no conditions or restrictions can be put only on the ground of sex. And therefore, the generalization of right to equality or general clause of right to equality under Article 14 was specified in Article 15 that on the sex of gender discrimination, though gender discrimination is not allowed under Article 14 also, but the Article 15 specifies that only on the basis of sex there shall not be any discrimination, only on the basis of sex there shall not be the imposition of any restriction or any condition. It means that women cannot be restricted, women cannot be subject to any condition which is imposed only on the ground of sex. So, the men and women are considered equal in both the articles, Article 14 and 15. Now, see Article 15 clause 3. These two provisions, Article 14, then Article 15 clause 1 and 15 clause 2. These are the general provisions where the discrimination is not allowed, though in Article 15 the sex has been made one ground on which the discrimination cannot be made, and therefore we can say that Article 15 clause 1 and clause 2, these two provisions can also be considered to be the special provisions protecting the women against any kind of discrimination. But Article 15 clause 3, it gives the power to the state to make any initiatives for the protection of women, and therefore it is the special provision protecting the women under the Constitution. Article 15 clause 3 says that nothing in this article shall prevent the state from making any special provisions for women and children. It becomes significant because of the fact that we see under Article 14 and in clause 1 and clause 2 of Article 15, the discrimination on the basis of sex is not allowed, the discrimination on the basis of the age of the person is not allowed, all are treated equal, men or women or the persons of any age. But at the same time, under Article 15 clause 3, it is provided that nothing under clause 1 and clause 2 of article 15 shall prevent the state from making any special provisions for women and children. It seems that the makers of our constitution, they properly knew the position, the vulnerable position of women and children. They were very well about the disadvantageous and marginalized status of women in Indian society. They were very well aware of the fact, they were very well knowing the fact that in Indian society, the women could not be subjected with equal treatment with men, and they have always been the subject of discrimination, tyranny, exploitation and subjugation in the hands of men. And therefore, this special provision was included in the constitution irrespective of article 14 and article 15 clause 1 and clause 2, where discrimination is not allowed on the basis of sex or on the basis of age. But because of this position or this status of women, and to liberalize the women from this status and to make the women equal to the men, the special provision was included as in the form of clause 3 of article 15, where the state is allowed to make special provisions for women and children. It is called as affirmative discrimination or positive discrimination. And this is the speciality of Indian constitution. This is the unique feature of our constitution, that though our constitution does not permit any kind of discrimination on any ground, but the affirmative discrimination is allowed, the positive discrimination is allowed to make those groups equal with the advanced groups, to make those people equal with the people who are in advantageous stage. And therefore, the affirmative discrimination in the form of article 15 clause 3 and also in the form of the different provisions in article 16, the positive or affirmative discrimination is allowed. The article 15 clause 3 is also one of those instances where the state is allowed to make affirmative discrimination, to make positive discrimination in favor of women and also in favor of children. Why? The constitution provided for the authority to the state for making special provisions for women and children both. Why not only for women? I have already told you that the children have been the responsibility of women mostly. Generally, the children are the responsibility of women in the family. And because the women are not independent either socially or economically, and therefore, the children have also been the subject of the same impediments to which the women were. And that was the reason the makers of our constitution, they gave the authority, they conferred the power on the state to make the special provisions, to make the positive discrimination in favor of women and children both. Then article 16 comes. Article 16 provides for the equality of opportunity in matters of public employment. Clause 1 of article 16 states that there shall be equality of opportunity for all citizens in matters relating to the employment or appointment to any office under the state. Clause 2 says that no citizen shall, on grounds only of religion, race, caste, sex, descent, place of birth, residence, or any of them, be ineligible or discriminated against in respect of any employment or office under the state. By these two clauses, two provisions of Article 16, Clause 1 and Clause 2, Article 16 guarantees the equality of opportunity in public employment. Under Article 16, the equality of opportunity is provided in matters of public employment, and it is the mandate of Indian Constitution that no citizen shall be discriminated on the ground of religion, race, caste, sex, place of birth or descent or even the residence. So, you can see some additional grounds which are found in the Article 16 Clause 2, which were not there in 15. These are the residence and the descent. No person shall be discriminated on the ground of sex, on the ground of religion, on the ground of caste, on the ground of place of birth, on the ground of descent, on the ground of residence. In matters of public employment, there shall be the equality of opportunity. But under Article 15, the positive discrimination can be made, and therefore, the Article 15, that mandate given to the state under Article 15 may also be applied in matters of employment, and it has been done that in various fields in the employment, women are given the reservation or women are given the special treatment. Some seats are being reserved for the women. And therefore, though Article 15 and 16 both do not allow the discrimination on the ground of sex, but because of the mandate of Article 15(3), the positive or affirmative discrimination can be made in favor of women. Then comes Article 39. See Article 39, certain principles of policy to be followed by the state. The state shall in particular direct its policy towards securing that the citizens, men and women, equally have the right to an adequate means of livelihood, that there is equal pay for equal work for both men and women, that the health and strength of workers, men and women, and the tender age of children are not abused, and that citizens are not forced by economic necessity to enter avocations unsuited to their age or strength. Under Article 39, the state shall in particular direct its policies towards securing what is to be secured by the state. Number 1, that the citizens, men and women, equally have the right to adequate means of livelihood. So, the men and women cannot be discriminated with matters of means of livelihood, both have the equal right to the means of livelihood. The men and women both have the right to equal pay for equal work. They cannot be on the basis of sex, they cannot be discriminated to make the payment for the same work. So, the men and women both are entitled the equal pay for the equal work. And number 3, that the health and strength of workers, men and women, and the tender age children are not abused. So, women and children, the health and strength of women and children when they work, that should not be abused, and they should not be sent to those avocations. They should not be compelled to do those works which are not suited to their age or strength, and this provision also relates to women and children. The children cannot be employed in those for those works which works are not suitable for their age, and likewise because of the distinction in the physical strength and structure of women, they cannot be employed in those works which are not suited to their strength, and therefore, the children and women both are protected by Article 39. See Article 39A. Article 39A directs the state to promote justice on the basis of equal opportunity and to promote free legal aid by suitable legislation or scheme or in any other way to ensure that opportunities for securing justice are not denied to any citizen by reason of economic or other disabilities. Opportunities for securing justice are not denied to any citizen by reason of economic or other disabilities. So, women, because economically they are weaker, they have other impediments also or other disabilities also. This also goes in favor of women, that the opportunity to secure the justice should not be denied to women only because of the reason that they do not have the economic capacity or they are otherwise disabled. Then comes Article 42. Article 42 directs the state to make provisions for securing justice and human conditions of work and for maternity relief. This is very significant provision with respect to the protection of rights, particularly the protection of rights of women during their employment. We know the unique characteristic of women, that they are mothers, and for being mothers they have to devote a certain time period for this great job which they do, this great object which they wear. So, for bearing the children and then for taking care of those small children, they need some special treatment during their employment. And if such a special treatment is not given, if such a positive or affirmative discrimination is not given in favor of women, then they cannot enjoy or they cannot avail their this or such natural right or the natural gift which has been given to them by God. And therefore, for the protection of this natural right, they should be given some special treatment. Article 42 directs the state for giving such special treatment to women and to grant them the maternity relief. For this purpose, the enactment has also been made by the Indian legislature, and now the women are entitled for the sufficient leave to give birth to the children or to protect or to take care of their small children. Then comes Article 51A, and it is also the 51AE, it is the part of fundamental duties which were added to the Constitution by 42nd Amendment in 1976. And this particular fundamental duty which is provided by the Constitution in Article 51AE inflicts a fundamental duty upon every citizen of the country to renounce the practices derogatory to the dignity of women. This is very revolutionary provision included in the Constitution by way of 42nd Amendment, that it is the fundamental duty of each and every citizen, that each and every citizen of the country is duty bound to renounce the practices derogatory to the dignity of women. So, the women must be respected, and any such practice which is derogatory to the dignity of women must be renounced by the citizens of our country. Some more provisions we can see which have been included in the Constitution to give the constitutional protection to the women, and these are considered to be the special provisions protecting the rights of women. We can refer to the 73rd Amendment to the Constitution. Article 40 becomes the basis of this 73rd Amendment. Under the directive principles of state policy, that is part 4, Article 40 states that the state shall take steps to organize village panchayats and endow them with such powers and authority as may be necessary to enable them to function as units of self-government. By 73rd Amendment, the directive which was given to the state under Article 40 was materialized, and to make the village panchayat more independent and more democratic bodies, the 73rd Amendment was made. To establish the real form of local self-government in the form of village panchayat, in the form of kshetra panchayat, in the form of jila panchayat, and in the form of urban self-government bodies like the nagar palika, nagar panchayat, municipal corporations, etc. Article 40 mandates the government, the state to make the policies to strengthen or to organize the village panchayat in such a manner so that they can become the local bodies of local self-government in real sense, and therefore 73rd Amendment was made. What is the meaning of local self-government? See, the local self-government refers to the institutions like Gram Panchayat, Kshetra Panchayat and the Jila Panchayat in rural areas, and the municipalities and the municipal corporations in the urban areas. The Indian Constitution was amended by way of 73rd Amendment in 1993 to fulfill the obligations imposed over the government under Article 40 and particularly to overcome then popular pressure on the government. The amendment also included the provisions to ensure the political participation of women in local self-government and to ensure the representation of women in various statutory bodies of local self-government. Several new provisions were added to Article 243 by way of this 73rd Amendment. See, Article 243D and Article 243T relates to the reservation of seats for women in local self-government. In Article 243D and in Article 243T, the reservation of seats has been made for the women. See clause 1, seats shall be reserved for A, the scheduled caste and the scheduled tribes in every panchayat. Then particularly the clause 2 of Article 243D, not less than 1/3 of the total number of seats reserved under clause 1 shall be reserved for women belonging to scheduled caste or, as the case may be, the scheduled tribes. In clause 1, the seats have been reserved for scheduled caste and scheduled tribes, but within that reservation also the horizontal reservation was given that out of these scheduled tribes and scheduled caste seats, at least 1/3, not less than 1/3 seats shall be reserved for the women. So, the women relating to or coming out of the scheduled caste and scheduled tribes society, they will also participate in the local self-government bodies because the 1/3 reservation has been given to them. Then clause 3, not less than 1/3, including the number of seats reserved for women belonging to the scheduled caste and the scheduled tribes, of the total number of seats to be filled by direct election in every panchayat shall be reserved for women, and such seats may be allotted by rotation to different constituencies in a panchayat. Total one hand, the 1/3 of the reserved seat in favor of scheduled tribes and scheduled caste, for women these are reserved, and on the other hand 1/3 of total number of seats, including the number of seats which are reserved for scheduled caste and scheduled tribe women, will be reserved for the women, and this reservation would be made in each panchayat by way of rotation. Not only the seats in the election or the seats in the electing bodies, but in the offices of also, see clause 4, the offices of the chairpersons in the panchayats at the village or any other level shall be reserved for the scheduled caste, the scheduled tribes and women in such manner as the legislature of the state may by law provide, provided that the number of office of chairpersons reserved for the scheduled caste and scheduled tribes in the panchayats at each level in any state shall bear as nearly as may be the same proportion to the total number of such offices in the panchayats at each level as the population of scheduled caste in the state or the scheduled tribes in the state bears to the total population of the state, and then provided further that not less than 1/3 of the total number of offices of chairpersons in the panchayats at each level shall be reserved for women. So, not only the members of village panchayat, Jila panchayat, Kshetra panchayat, also the offices of chairpersons like Gram Pradhan, Mukhiya, Block Pramukh, Jila panchayat Adhyaksh, these seats will also be reserved for women, at least 1/3 of total number of seats. Then comes Article 243T. This also refers to the reservation for women, clause 2, C clause 2, not less than 1/3 of the total number of seats reserved under clause 1 shall be reserved for women belonging to the scheduled caste or the scheduled tribes as the case may be. And this 243T refers to the reservation in the municipalities, municipal areas, and that is the urban local self government bodies. The same provision has been made that the 1/3 of the seats reserved for scheduled tribes will go to the women, and less than 1/3 of the total number of seats to be filled by direct election, every municipality shall reserve for the women. Again, the same provision, chairpersons, for the chairpersons also 1/3 seats will go to the women. Then comes 128 constitutional amendment recently in 2023, which we know in the name of Women Reservation Bill or the Women Reservation Act. Now, 1/3 seats were reserved by 73rd Amendment in 1993 with respect to the seats or the elections at the rural self government bodies, village panchayat, Kshetra panchayat, Jila panchayat, and the urban self government bodies like municipalities and municipal corporations. In the same way, by way of 128 amendment, the seats have been reserved for the women in the elections of assemblies in states and in the elections of the parliamentary elections or the Lok Sabha elections at the center. This amendment was made to enable greater participation of women as people's representation in policy making by parliament and state legislatures at both the national and state level. The constitutional amendment provides for reserving 1/3 seats for women in the House of the People, a parliament, that is Lok Sabha, and the legislative assemblies in every state legislature. For this purpose, Article 239AA, Article 330, Article 332 and Article 334 were amended to ensure the above mentioned women reservation in elections for Lok Sabha and popular house of state legislatures. So, this is also important to know that these articles were amended by way of 128 amendment to give the reservation to the women in the Lok Sabha elections and the assembly elections in the states. Now, the constitutional protection to the children. Children also need the special care for their health, for their nutrition, for play, for early learning, within protective and enabling environment, because this stage of development, it builds indispensable foundation for lifelong learning in the life of a person, and therefore, the childhood, it becomes very significant part of the life for any person to make or to see his or her future. The supreme law of the land, that is the Constitution of India, considered the same demand or the same need, same requirement with respect to children, and it included certain special provisions to protect the rights of children or to give them the opportunity to be developed in free environment or to make the foundation of their life on which they can become the sound citizen of this country. See, the makers of Indian Constitution, they were sufficiently aware, cautious and concerned about the need, relevance and the importance of child care, protection and education. Idea of including several provisions in the Constitution for ensuring the welfare, the development of children is the substantiation of their great vision to recognize the significant role of child care, protection and education in achieving the constitutional goal of holistic development and progress of our nation. Without providing the substantial opportunity to the children to develop, without providing the proper opportunity to the childhood to develop, the holistic development and progress of nation is not possible, because these children are the future human resource and this age is very sensitive for the future development of a person. Many scientific researches have proved or established that the age from 0 to or from 3 to 6 particularly, from 0 to 6 in general, this is very crucial age for the development of brain of a child. And during this age, the brain of the child develops very vigorously, very rapidly, and therefore, this is the age on which the focus should be made on the development of the child. The fundamental rights, the directive principles of state policy containing such provisions have been the source and foundation of inspiration of the legislators for making law, policies, schemes and programs for the care, protection, education and development of the children in the country. Now, see the provisions which are specially made or included in the Constitution for the protection of the rights of the children or to take care of the rights of the children. Again, we can refer Article 15 clause 3. Under Article 15 clause 3, the state is empowered or the state is given the authority to make the special provisions for women and children. Under Article 15(3), I have already told you that the state can make the positive discrimination, the affirmative discrimination in favor of women. Similarly, the state can make the positive or affirmative discrimination in favor of children. Though our Constitution or particularly Article 15, Article 14 do not allow the discrimination on the basis of age of any person, but with regard to the children, Article 15 clause 3 gives the authority to state to make special provisions to make the affirmative discrimination. State includes both the legislature and the executive, and therefore, under this provision the legislature as well the executive, the legislature can take the legislative initiatives, meaning thereby the legislature can make the law, can lay down the law, can enact the legislations for the protection of the rights of the children, especially by giving the special treatment to them by making the positive discrimination, and the executive can take the executive initiatives in this regard. Then Article 21, the Supreme Court of India emphasizes and highlights the need and significance of care, protection, education and development of children. In this regard, right to free education of the children up to the age of 14 years was recognized by the Apex Indian Court in the case of Unni Krishnan versus State of Andhra Pradesh. This Unni Krishnan versus State of Andhra Pradesh, before Unni Krishnan case, the case of Mohini Jain was decided by the Supreme Court of India. And in the Mohini Jain case, this right to education, not the right to education of children only, the right to education of all the persons, all the individuals was recognized. But Unni Krishnan case modified the verdict of the Supreme Court. The Supreme Court itself modified its verdict in Mohini Jain case and decided that this is the right of the children up to the 14 years only to have the fundamental right of education. So, right to education of the children was first time recognized as fundamental rights, right, within the ambit of, within the scope of Article 21, right to life and personal liberty. Then, when this right to education was recognized by the Supreme Court of India in Unni Krishnan case, right to education of children, in 1993, in due course of time, Indian legislature realized the need of the children's right to education. Accordingly, Indian Parliament amended the constitution to this effect by inserting Article 21A in part 3 in the constitution by way of 86th amendment in the constitution. See, in 1993, the Unni Krishnan case was decided, which recognizes the fundamental right of children to education, fundamental right to education of children under Article 21, but only in 2002 the Indian legislature could enact the law to recognize the right to education of children, and Article 21A was added to part 3 after Article 21. So, right to education of children was made the part of fundamental right. You can see the transformation of the constitutional law, where the directive principles are getting the shape of fundamental rights. This was the directive under Article 45 to take care of the education, care and protection of the children from 6 to 14 years, and that directive principle of Article 45 was given the form of fundamental right by adding, by including, by inserting Article 21A in the constitution. This Article 21A of our constitution recognizes the right to education of children only from 6 to 14 years. Still, the right of the children below 6 years of their care, protection and education could not become the fundamental right. By the same amendment, that is 86th amendment in 2002, the Article 45 of the constitution was also amended, and this Article 45 of the constitution, which was amended by the same amendment, substituted by newly worded Article 45. See, the state shall endeavour to provide early childhood care and education for all children until they complete the age of 6 years. It means that the children from 6 to 14 years were given the fundamental right, were given the right to education as the fundamental right by way of the inclusion of article 21A, but the article 45, the earlier article or original article 45 was substituted by newly worded article 45 by 86th amendment, and it was the directive, or it has been made the directive to the state, which is not enforceable, that the state would take into consideration at the time of making its policies to take care of the care, protection and education of early childhood, that is the care, protection and education of the children from 0 to 6 years. Then article 24 provides protection to the children below the age of 14 years from any hazardous employment. It is right against exploitation under our constitution, and it provides the protection to the children below the age of 14 years from any hazardous employment. Then article 39E recognizes the right of children of tender age to be protected from being abused and forced by economic necessity to enter occupations unsuited to their age or strength. Article 39F, it recognizes the right of children to equal opportunity and facilities to develop in a healthy manner and in conditions of freedom and dignity. Article 39F also guarantees protection to childhood and youth against exploitation, against moral and material abandonment. Now, see, the constitution provides for the right to education of the children from 6 to 14 years, then it has been made the directive principle for the children below 6 years. Article 24 protects against any kind of exploitation, and particularly with respect to the children below the age of 14 years, they are protected from any kind of hazardous employment. Article 39E and 39F also gives the protection to the children. Then one important aspect which is also important to be discussed here with reference to the right to education of the children below 6 years. This was the same year in 2002, the amendment 86th amendment was made, and before 2002, in the year of 2000, one commission was constituted by Indian government, that is known as Venkat Chalaiya Commission. The official name of Venkat Chalaiya Commission was the Commission to review the working of the constitution. Though the commission recommended the several changes in the constitution, but with respect to the rights of children, the Venkat Chalaiya Commission made a precious recommendation for achieving the objective of early childhood care and education, that the right to free and compulsory education should be extended to all children up to the age of 14 years. Under article 21A, it has been given to the children only from 6 to 14 years. The Venkat Chalaiya Commission recommended that this right to free and compulsory education, should be extended to all children up to the age of 14 years and not only from the age of 6 to 14. In this regard, the Commission recommended the inclusion of article 30C in part 3 of the Indian Constitution. The Commission was of the view that early childhood care and education should also be taken into account, and therefore, the Commission recommended for the amendment in the Constitution. The Commission was very much aware of the fact that the interest involved in early childhood care and education are intricate and intertwined and therefore cannot be addressed only by enacting right to education. The Commission envisioned that in addition to the guarantee of right to education, there is eminent need for recognizing right to care and protection as fundamental right, because early childhood cannot be protected only by recognizing the right to education. In addition to right to education, right to care and protection should also be recognized, and for this purpose the article 24A in part 3 should be added. It was recommended by the Venkat Commission. Venkat Commission also recommended that there shall be expansion of the scope of article 21A with a view to cover the children under the age of 6 years and to create new fundamental right of child's care and protection as 24A. And it could have been very positive and revolutionary step towards creating a responsible legal regime to ensure the effective foundation of early childhood care and education. If these all the recommendations of Venkat Commission are adopted by the government and accordingly the constitution is amended, if article 24A is included to take care of the care and protection of the children, if article 30C is included to ensure the education of the children from 0 to 6 years, and if article 21A, which has already been included in the constitution, is amended in the same spirit as recommended by the Venkat Commission, it would be the great contribution of our government to ensure the right to care, protection and education of children up to 14 years. This is all about the constitutional protection to women and children. Thank you.
Hello and welcome to this piece of literary snippet. We usually know William Shakespeare as the most revered figure in the history of English literature. But we often tend to forget that he has also been one of the most hated figures in literature. And here I am not talking only about those boys and girls who have to memorize long sections from Macbeth or King Lear or Julius Caesar before they can go and sit for their school or college exams. But I am also talking about people who are themselves quite famous authors. Tolstoy, for instance, considered the writings of Shakespeare to be, and I quote, crude, immoral, vulgar and senseless. George Bernard Shaw absolutely loathed Shakespeare, as he did Homer. But perhaps no other criticism about Shakespeare is more damaging than the one which says that Shakespeare is a marvelous storyteller, provided someone has told him the story earlier. Now, this piece of criticism is particularly damaging because it is true. None of Shakespeare's plays contain any original story whatsoever. They are all written using pre-existing materials, pre-existing stories. Now, does that diminish the stature of Shakespeare as a dramatist? Well, I'll leave that for you to decide. See you in the next episode of Literary Snippets.